4.4, getting the city's money for Toll's Garden from Henderson Franklin Law Firm. Councilmember Burson.
Thank you, Mayor. You know, I've heard these speakers tonight, and I wish them the best of luck in getting Toll's Garden done. I don't want to stand in their way. However, the item tonight doesn't involve them. It involves the former owner, Mr. Macfarlane, who had agreed to go vertical, and if he did not go vertical, he would pay us for the land that we gifted him. And that's what the deposit represents, payment for the land that was gifted if he did not go vertical. So while I hope that the new owners are successful in their endeavor, my issue is not with them. Mr. Macfarlane failed to go vertical, and therefore, per the agreement he signed with us, we're entitled to that money, and that's what I'm asking for. I don't wish any ill will on the new owners, but the truth of the matter is he conveyed that property to the new owners in the form of a warranty deed back on July the 20th of 2023. From that point in time, they have been the owners. And they come forward tonight saying that they need more time. Well, I don't mind them coming forward, but you know, I've probably met with representatives of Toll Gardens probably close to 20 times over the last 5 years. I really don't need to meet with them to hear what they're going to do. I would rather see what they're going to do. So again, my issue is not with the new owners, it's with the fact that the previous owner failed in his obligation to do what he said he was going to do, and we're entitled to that money. It was contractual. It was gifted to him with the idea that he would go vertical. He did not go vertical, and therefore we're entitled to the payment of that funds, and I hope the new owners can finally accomplish what they say they're going to do. But that doesn't stop us from the fact that we're entitled to that money, and I'm going to make a motion that we go ahead and proceed to start the collection of that money. When we delayed it to December the 4th of 2024, back in December, nothing was mentioned that the property was already out of the name of Mr. Macfarlane. He had already sold it 6 months earlier. And so for myself, it borderlines, I think it borderlines fraud because he misrepresented his ownership. He was not the owner. He was asking for something he was not entitled to. He had already sold it. So I'm going to make a motion tonight that we go ahead and reclaim that money, and rather than wait till December the 4th, because December the 4th has nothing to do with the new owners. And so that is my motion, that we start the process to get the money that we're entitled to when we sold the property to Mr. Macfarlane 5 years ago. And that is my motion.
Okay, we have a motion. Do we have a second?
Yeah, I'll second the motion.
We have a motion by Councilmember Burson, second by Councilmember Bonk. Discussion.
Just a discussion. I would ask Mr. Burson if you would be open to amending the motion so that it is cut and dry and free and clear, that the extension for December would be null and void, that we would take back the escrow money, and then that would clear that out, and then we would begin to start over.
Absolutely. I would amend it to reflect what you just stated.
Councilmember Bochette.
Thank you, Mr. Mayor. Rewards come from production, not from promises, and we bought a lot of promises. However, this is a new group, and we need to, as I agree, we wipe the slate clean. Even if we have to give them just enough time to reorder 30 days or something, but basically they could go through this whole reprocess themselves, get on the stick, and I think we're going to be embracing them to move faster, move better, and show us some production. But I would like to embrace them, but I think we do need to get the past behind us.
I have a question for either the city manager or the city attorney. How does this affect the new owners going forward? Are we denying them anything by taking this action, or?
I think that the amendment to the motion resolves the legal issues. In other words, right now they're on track for a December deadline, and that's the last time the council has spoken on this issue. And so, as I understand the amended motion, the council would be voting to nullify that deadline, and it would be a declaration of default, and then we would pursue, as Councilperson Burson said, initiate the process of there is a process to pursue the escrow with the escrow agent. How it impacts the group, I don't know. They would have to articulate that. But looking at it from a legal perspective, there are grounds for default, and it's a different track now than what we're on, so it should be changed.
So I understand that. I understand the failure on the part of Mr. Macfarlane. My concern is we have a lot invested in this project as a city. I don't know if we can afford not to see it happen, and it concerns me. Councilmember Streets.
Thank you, Mr. Mayor. You sort of touched on what I was going to talk about. Even I understand what Ward 5 and Ward 6 is talking about. But as you and I were discussing, Mr. Alley, about the default clause, before that we could determine here tonight a course of action that will reclaim the money, I think the process that we talked about has to be played out. I don't know about this null and void, but he does have to be legally notified that he's in default and an opportunity to respond. I'm not a lawyer, but I play one on the weekends.
You're correct. There's a notice provision, an opportunity to cure.
But and that's all. I think that the Fuse organization is asking that an opportunity to perhaps during that time there may be an agreement that we can continue to move forward. So that's just my comment, Mr. Mayor.
Councilmember Watkins Brown.
And I just had a question. Is there any way we can regain the amount of money for the land and then allow the December the 4th date to continue to go through? I mean, I've met with them, and I've told them, especially on Prima Luce, they're going to have to do a whole new application process. So since we have on being the CRA commissioner side, as well as the city side, giving them this drop date of December 4th, can we continue to proceed with that date, but still request the money back that we gave as far as the land is concerned?
I'm not opposed to working with the new group. However, our contractual arrangements was with Bob Macfarlane. Mr. Macfarlane did not ever come to us and ask us to assign it to the new owners. The new owners never came to us and asked us for an assignment. The bottom line is he did not perform. He misled us. He on a warranty deed dated July the 20th of 2023, he sold the property. That violates the contract. We don't have to start the process, and we don't have to put him on notice. he put us on notice when he conveyed it to somebody else. Now, if they come back and ask us for help, I'm not opposed to maybe considering whatever help they might need. But at this point in time, we're entitled to that money, and if we feel like giving it away again in the future, we may. But it doesn't need to be held by an escrow pending something that's going to be promised again and again and again.
And that's not really what I'm saying. I'm not saying hold it until December the 4th. I'm saying get the money back, but then allow them to proceed with the process of getting the...
I have no bone with them.
Yeah.
All right,
I don't know 'em.
Councilmember Bonk.
Thank you. Iterating kind of both comments from Mr. Burson and Ms. Brown in the sense of the contract was with Macfarlane and they defaulted. And so with that, for the protection of all parties, emotion aside of how much we want to see a project go through, the contract states action was required. The action was not done, and the reason why we had the amount of money in escrow was to protect ourselves in the event this happened. This has happened. We have the right to go take that back. The process is to notify Mr. McFarland he's in default, and so that would negate the December 4th deadline, allowing us to take back the escrow. Clearing that off, then we can move forward with Fuse, which from a community perspective, we can show we are behind Fuse LLC. We hope that they're able to make Toll's Garden take place, but it does not entangle that with the previous owner. It's free and clear, and it makes everybody whole, and it protects all parties from a legal and contractual basis. It has nothing to do with the emotion of whether or not we want to see something get built.
So, Council, is it safe to say to let the Fuse group know we are supportive of your efforts to make this project happen, and staff knows that and will work with you to make this come through? Councilmember Bochet.
Thank you, Mr. Mayor. Let me add in here that I listened to our city attorney very closely. We don't want to have a misstep, and it's going to take time for this notification. It'll be, I assume it's weeks, but in the meantime, that gives them until we recover those funds to get an application in for our consideration. So I think the time lapse, agreeing with Councilman Burson, agreeing with Councilperson Bach, and also agreeing with what can we do to make it easier for them. If there's a time lapse overlap before we can follow the process, and if they fill that gap with a suitable request, we can consider it that time. So it's not really, we're not running to the bank tomorrow and fill up the check. But there's a process to go through. So if I would challenge them to say, put it in writing, give us the promises, and the security, the collateral, or whatever it takes to back that up. And in 2 weeks, we'll be here again, or the next month. Whatever that time the attorney feels the time to get that money back would be, they have the time to resolicit and convince us. Because I agree with Councilperson Bach, the agreement we made was with a different party, and it should be over. However, in this time lapse period, if they can step up and fill that gap, we could consider it. So I guess what I'm saying is,
You're saying the time lapse period to December 4th?
no, whatever the attorney says.
By the time lapse.
Very good. So I think Councilman Street was also saying that, this is, and the mayor, this is something we really want to see done. Help us help you get it done.
I think we're all in agreement on that. Mr. City Attorney.
I want to be clear. We did an RFP. FJ Services, and I can't remember where Mr. McFarland's company, he's the principal, they won. They both won the RFP. They both won the procurement. We entered into an agreement. We are in privity of contract with them. Privity of contract is a legal term. It means we have a contract with them. The contract outlines processes for default. The contract outlines what happens to the escrow, what happens to the land, the city's commitment, what we paid already, site clearing, don't hold me to the number, but it's a high figure. It's in the hundreds of thousands of dollars. The new group, there would have to be either an assumption or if they come in under that contract, and that would have to be approved or considered or denied by the mayor and city council. There are multiple financing parties involved in this. So it is important that we don't misstep, because we don't want one of the financiers to pull out that we have nothing to do with. County, state, or I don't know all the parties that are involved, but I can outline them and look it up for you tonight. So if to pursue this, we declare a default, we give an opportunity to cure, and then we move in that direction. The declaration of default is a legal act, and it'll have consequences.
I have a
Mr. Street.
thank you, Mr. Mayor. During that time, Mr. Alley, will that entail perhaps maybe the Fuse organization, while the process is taking place in regards to the default, does that exclude them from working with us and the CRA, because they're involved in it too, to move forward and come up with a collaborative effort so that we can continue to move forward? Or are we just looking just to reclaim the $500,000?
It shouldn't. They own the land, so they should be able to move. It shouldn't impact them.
For myself, I'm not opposed to building affordable housing. But my issue is Mr. Macfarlane defaulted. We're entitled to the money. If this new group steps forward and we feel like we want to work with them as a council, we can award it at a different time. We can award a different amount. We can award whatever we think is necessary to get it done if they have the wherewithal to do it. But the $560,000 does not belong to them in no way, shape, or form. And I mean, really,
I understand.
we just need to cut ties on that deposit, and if the new group that now owns it is worthwhile and we feel like we want to make a contribution to their efforts, we can. I'm not opposed to them. I want to see it done.
Mr.
But that
Streets.
has nothing, there's two different issues. The money belongs to us, and now if the new group wants to present a plan that we as council support, then we can. And if we don't, they own the land, they can go their merry way.
Councilmember Streets.
Thank you again, Mr. Mayor. Mr. Burson, I think there was another entity that perhaps maybe is contractual with us, but there's another company involved in us also. FJ, you know, let's not take everything away from them. They're still involved in the process, and they have come forth tonight with a group that says we can get it done. I'm not so much, if that's what you want to do, and I'm just only one vote, but I'm saying if that's what you want the money, fine, that's Mr. Macfarlane. But there's still another contract along with this group. And when you get people who saying that they'll do it, because I think we still have to, there's perhaps a TIF agreement with the CRA. So I think that if anything, I would ask you to amend your motion to give them an opportunity to work with Grant, the city manager, and the CRA and everybody else, and see what we can come up with. I'm not opposed if that's what you want to do, but I want everybody to go away thinking that they won except Mr. Macfarlane.
Councilmember Ball.
Question, Mr. Streets. In bringing in Fuse and FSJF into this conversation, to me that is muddying the waters, because I don't want them to have to pay the penalty, perceived or otherwise, when we can clean up what was defaulted on and potentially move forward without there being a tie to what was not done, although promised for 5 years beforehand. So I don't want to do anything that would negate a new group that is now the lender owner today or 6 months ago from being impacted by what was not done before. So to me, cleaning that up and separating those two things helps them do that.
Absolutely.
Well,
And I mean, what would be the purpose in them keeping the $560,000 anyway? I mean, we don't own the land, so it pays us for what we gave to them. That was my point.
And there's nothing that prevents us for using that money in the future if the need arises
Support them.
to help them.
Need it, yeah.
All right, Madam Clerk, if we could have a roll call vote, please.
Restate the motion.
Yes, if you can restate the motion.
I thought you were going to say that.
I have, the motion is to provide the extension, or for the extension for the December to be null and void and take back the escrow money.
Okay.
Well, I think it was a little more than that.
The
That's the gist.
Macfarlane Group needs to be notified of the default.
So basically, it's
You got to have that part in it because
we're voting. Yes.
to cure, and upon their inability to cure, we begin the process to take the amount of money that's in the escrow account.
Okay, Madam Clerk, roll call
I have a
vote.
question, Mr. Mayor. What's the time limit of responding to the default?
Good question. For curing, yeah.
I'm looking up, is Mr. Belvin is here, he perhaps could answer that. I'm trying to pull the contract up now. I believe it's 30 days, but that's going off of reviewing it. I haven't looked at it today. That's a specific question. I believe it's 30 days, a right to cure. You want to tell him, or do you want me to? Okay.
Well, with all due respect, the 30 days passed back in August of 2023. He transferred on July the 20th.
Okay, the vote's been called for, discussion's over, so Madam Clerk.
Councilperson Burson,
Yes.
Councilperson Bonk,
Yes.
Councilperson Brown,
Yes.
Councilperson Streets,
No?
Councilperson Watson. Oh, she's not there. Councilperson Bochette,
Yes.
Mayor Anderson.
Yes.
Motion carries.
Thank you. Gentlemen, I hope you see that this council is committed to seeing this project come through. And staff will be working with you to hopefully get it going.
Well, I have a question, Mr. Mayor.
Yes.
For the city attorney. Now, does this body has to go over to the CRA commissioners and do the same thing?
No, the contract was for the escrow was with the city, not with the
City,
CRA.
Not the CRA. The only thing the CRA had was the TIF
TIF.
agreement, which new applications will probably have to be done.
I would have to review the TIF agreement to see if it contains a compliance clause.
And yeah, in most cases, the TIF has transferred over when the property was sold. Regardless, they can, if it doesn't transfer, we encourage you to reapply. All right, thank you. That brings us to Section 5, Public Hearings. 5.1 is ordinance number 4011. City Attorney Alley, would you read the title, please?
4.5, we're not.
Excuse me. 4.5, Councilmember Bonk.
Thank you. So last council meeting, we talked about the potential for